Hi, my name is Jeff Butler. I'm an attorney and also a partner at the law office of Pearson & Butler here in Utah. One of the services we do offer our clients is loan modification services. There's been some new regulations, a new directive that is taking effect on June 1st, 2010. I'd like to talk with you about that. But before I do, I'd like to begin with a disclaimer. The information I'm providing in this video is for general information purposes only and not intended to convey a legal opinion or legal advice for any particular case or situation. Also, this information does not represent a complete discussion of all the issues and items that have been addressed in the guidelines that take effect on June 1st. And since every individual's factual situation is different, independent legal advice regarding specific situation from a licensed attorney is advisable. The new Home Affordable Modification Program, which is also known as HAMP or the Obama Plan, has loan modification guidelines that are taking effect on June 1st. On March 24th, 2010, the federal government provided new HAMP borrower outreach and communication guidelines for foreclosure actions while a borrower is being evaluated under HAMP. The guidelines also provide more protection for delinquent borrowers who have filed bankruptcy but would otherwise be eligible for HAMP benefits. For details, see Supplemental Directive 10-02. Highlights from the directive include the following. Relating to foreclosure, there's additional foreclosure steps that the federal government is now requiring the banks, the servicers, and the lenders to participate in and follow through with if they are receiving HAMP money. First, the servicer must evaluate the borrower's eligibility under HAMP and determine that the borrower is ineligible before referring the borrower to foreclosure, or at least the lender or servicer must make reasonable solicitation efforts to contact the borrower to determine eligibility. This is very big. I've had clients in the past who've wanted to get loan modifications, but because they have a foreclosure date set at a certain time, the banks have been unwilling to consider people under HAMP because they figure there's not enough time. This directive provides more teeth to require these lenders and these servicers to actually look at a client under a modification before just foreclosing on them. Secondly, if the foreclosure activity has already been initiated, the foreclosure sale cannot occur until after the servicer has determined the borrower is ineligible under HAMP, or again, at least the lender makes reasonable solicitation efforts to communicate with the homeowner. Some homeowners do not want to keep their homes. They just as soon be foreclosed on or lose their home rather than see if they qualify under HAMP. I've never understood that, but that happens. And so as long as the bank's making a reasonable solicitation effort to communicate with the borrower, they can move forward with foreclosures. But those people who are homeowners that are delinquent that actually want to keep their home, this directive is wonderful because it does require the banks and the servicers to seriously consider these people under the Home Affordability Modification Program. The third is that the servicer must give the borrower 30 days to respond to HAMP non-approval notices in certain circumstances before conducting the foreclosure sale. So in other words, if a person's being foreclosed on, they applied for HAMP, they were not approved for HAMP, that homeowner, that borrower has 30 days to respond before that home would be foreclosed on in certain circumstances. And finally, fourth, the servicer must provide the foreclosure attorney certification in writing that the borrower is ineligible for HAMP before conducting the foreclosure sale. These four new directives are very, very helpful to the homeowners, and I'm happy to see that the federal government has been pushing forward to help these homeowners out. Similarly, there's new provisions that are protecting borrowers who are in active bankruptcy under Chapter 7s and Chapter 13s, and I wanted to really quickly hit those as well. If a homeowner is in an active Chapter 7 or 13 bankruptcy, and if that borrower or their attorney or the bankruptcy trustee requests, the servicer must consider the borrower under HAMP. Before this, has taken effect, borrowers would sometimes be denied for a loan modification under HAMP under what the banks had termed a, quote, proper exercise of discretion. Now that terminology will no longer be used. Similarly, if the borrower has been approved on a trial modification and files a Chapter 7 or Chapter 13 while they are under this trial modification, the servicer may not deny the borrower for a permanent modification only because of filing bankruptcy. Also, if a delinquent borrower has a discharged Chapter 7 and in that Chapter 7 they chose not to reaffirm the first lien mortgage debt, that borrower still is eligible under HAMP with the following provisions added to the permanent modification agreement. Quote, I was discharged in Chapter 7 bankruptcy proceeding subsequent to the execution of the loan documents. Based on this representation, lender agrees that I will not have personal liability on the debt pursuant to this agreement. For details, see Supplemental Directive 10-02. And if you are a homeowner struggling to make your first lien mortgage payment or feel like your lender or servicer has not worked with you on a loan modification, call Pearson & Butler, call my law firm, and see if one of our attorneys may be able to help you either for a loan modification or for bankruptcy assistance. Our Utah lawyers are happy to offer prospective clients a free consultation to see if there's ways to stop foreclosure. Also, if you need help with a Utah Chapter 7 or Chapter 13, we would be happy to help you in that area as well. At the law office of Pearson & Butler, our attorneys offer free loan modification consultations and bankruptcy consultations. If you are struggling with debt and want to look at the legal options available to you here in Utah, feel free to give us a call. You can reach one of our attorneys at 801-303-0557. Thank you.